Okay, well, we'll start with appearances. Counsel for plaintiff, please. Counsels.
Good morning, Your Honor. Eric Pepperman for plaintiffs.
And good morning, Your Honor. Teddy Parker on behalf of.
Good morning,
Okay.
David Spurlock on behalf of Whole Foods.
You want to do the rest of your clients so that we get clear?
United Natural Foods, Your Honor, and Whole Foods Market.
Okay, Scientific Instruments, who do we have?
Good morning, Your Honor. This is Ryan Flanagan for Scientific Instruments, Hanna Instruments, Inc., and SID.
Okay. Going next to NSF International, please.
Good morning, Your Honor. Jonathan Fountain for NSF.
Thank you. Albertsons, please.
Your Honor, Albertsons has been dismissed from the case.
Okay, Albertsons still appears, so please.
I promise, Your Honor, we've been working on it.
I know. Like I said, I keep calling because it keeps on showing up because presumably.
They're on there.
Yeah.
I know,
No
Your
worries.
Honor, we're working with the clerk's office to try to remedy that.
No worries. Thank you. Appreciate the heads up. Okay, we're next going to Milwaukee Instruments, please. Anyone from Milwaukee Instruments?
If you like, Your Honor, I can give a quick e-text to Mr. Robbins.
I'm going to keep going, but yeah, I mean, Costco Wholesale.
Good morning, Your Honor. Daniela LaBounty for defending Costco.
Anybody else on Costco? No?
We have our ProHawk counsel. She's on mute, I think.
Did you?
Your Honor, Noushan Noureddini, also on behalf of Costco.
I'm not requiring people to make appearances as long as I have one, but usually y'all like to, so, okay. ETT1, please.
Good morning, Your Honor. Jan Tomasik for ETT1.
Thank you. Real Water, please. And Affinity, go ahead.
Good morning, Your Honor. Joe Odou on behalf of AffinityLifestyles.com, Inc., doing business as Real Water, Inc., and third-party defendant, Real Water Gold Coast.
Nevada Beverage.
Morning, Your Honor. Colt Dodrill, Bar 9000, counsel for Nevada Beverage.
And we'll touch base on that. Let me get through the appearances and then we'll circle back to that issue. Okay, ready to United. Costco, ETT, Real Water of Tennessee, please.
Morning, Your Honor. Jim Cavanaugh, Gordon Reeves for third-party defendant, Real Water of Tennessee.
Appreciate it. And we already said Kihei is not in the case anymore, correct? Oh, is Kihei here or not?
Good morning, Your Honor. This is Laureen Frister. I represent Kihei Distributors of Nevada. We are not a party to this case, and we have worked with the clerk to try to get us off of your list, but we were told we can't be removed, but we were listed now as participant or other.
Okay. I do see it says other, but other doesn't tell not your issue, but other doesn't tell the court, you know what I mean? Okay, so you're not in the, does everyone agree they're not in the case? Should I do a motion to strike them from the pleading caption, folks? Would that help you? Or it's lovely to see you. I mean,
that would be very helpful. Thank you, Your Honor.
Any objection from counsels for plaintiff?
No objection, Your Honor.
Okay, so let's make a note that we'll try it on our end. Lovely to see you, but okay, just try not to have people have to come to court when.
Your Honor, if we could include Albertsons in that order, I think that'll help clear them off the docket as well.
Sure, let's get that taken care of. Appreciate it. Thanks so much. We do have a couple others. I've got a terrible herb shows up, but then I have it as ETT1. So why I have it both ways, I don't know. Can counsel for ETT1 jump?
Good morning, Judge. ETT1 does business as Terrible Herbs, and that's the reason for both names showing up.
No, I understand why you have that. Just to let you know, it shows as a separate entry. So, okay, I'm just going to ignore that from the future, since you all are on the same page as the case parties in this case. So, okay, so what makes the most sense is what's on today is the motion for settlement agreement and a joinder there too. But before I get to that, it seems to me it makes more sense that I've got Nevada Beverage has submitted their motion for good faith settlement on OST and then a motion to seal and redact related thereto. So it seems to me, since they are a joinder party in the underlying motions, you all might want me to address that and see if anybody minds, if anyone's going to raise an objection to the OST. If not, there's good cause to set the OST, and I was going to get that taken care of, and then I was going to see if there was a position that Nevada Beverage was going to have on the underlying motion in light of the underlying motion for settlement conference in light of the fact that they have a pending motion for good faith settlement. Anyone disagree with going there? Let me know, because if anyone thinks that I shouldn't address that because it's not technically on for today, please tell me now. Seems the most efficient use of everyone's time, right? Okay. So, does anyone object? Well, first off, let me hear from you. Counsel for Nevada Beverage, would you like that, or do you want to just keep coming?
I'd like the OST, Your Honor. I think that makes sense, and everyone's here, and we can be efficient.
Okay. So, realistically, I was going to set it sometime next week on Tuesday or Thursday. Next Thursday, any reason not to? Don't want to take everyone's time on just scheduling here, but okay. Anyone? I don't want to limit any. Is anyone? You don't need to necessarily tell me now, but if you want a viewpoint of when I set opposition dates, now might be the time to do it. If anyone thinks they're going to oppose it, if you'd rather not give your strategy, that's fine too. We'll just pick an opposition date. I'm just trying to, since I have everybody here, if it matters to somebody. And anybody here in court? No.
Nothing from the plaintiff, Your Honor.
I'm assuming plaintiff, yeah.
We're in agreement.
That might be the case. Okay, anybody remotely? No. Okay, then we're just going to pick dates and we'll get that taken care of for you all. Okay, so now I'm going to go to the motion before the court. The motion is for a mandatory settlement conference. Counsel, before you leave, on behalf of Nevada Beverage, is yours moot in light of your motion for good faith settlement, or do you still wish to be heard on your non-substantive joinder for a motion for settlement conference? Counsel for Nevada Beverage.
Your Honor, I suppose it's moot in light of my settlement, although the lawyer inside me still thinks it'd be a good idea for everyone else.
Wait, counsel, friendly reminder, remember we always need to say your name because there's lots of you.
Thank you, Your Honor. Colt Dodrill, Bar 9000, Counsel for Nevada Beverage. I suppose my non-substantive joinder is moot, but as an attorney, I still think it makes sense in light of everything else that's going on.
Counsel, am I addressing that as you're saying you have standing to take that position? I'm really kind of going for the simple thing. Since I don't have a signed order, right, Division of Family Services and Russ versus Clark County, you're technically, it's not moot because you haven't yet had the hearing. Motions have not yet been ruled on relating to you. I just want to know if you want an opportunity to be heard. Yes or no, please?
I don't need to be heard. Thank you, Your Honor.
No worries. If you do, it's fine. I just want to make sure we've got the same playing field. Okay, so counsel for movement. Would you like to go ahead? Nevada Beverage. I'm sorry. I'm sorry, I meant to say Whole Foods. Go ahead, counsel.
Your Honor, since we filed the motion, we have settled as well.
Oh.
So it becomes kind of moot, and we will be filing our motion for good faith settlement.
Well, I should let you start out with that one, right?
That is correct, Your Honor. And
it's Halloween. It's kind of the treat, Your Honor, we were giving the court.
I thought it was the Nevada Day Special.
We can give it that too.
And it's the Nevada Day Special.
Nevada Day Special. Well, congratulations. Thank you so very much. Depending on how quickly yours is on, I might try and jointly set them at the same time. Would it make sense for me to put it off to the following week so that you have time to get yours on? Not saying I will have to evaluate any OST as soon as it comes before me. You all want those put on the same?
I think it makes sense, Your Honor, to do it that way.
Okay. Do you think you're going to get it in like in the next day so it still can be next Thursday, or am I going to be putting it off to the following week?
I would suggest we put it off to the following week, Your Honor.
Any objection by Nevada Beverage if I put your OST off to the following week to see if maybe there can be two done on the same day to save people's time?
That the 9th or the 16th?
I don't know. What do you want, Whole Foods?
I would suggest the 16th, Your Honor.
That work okay
Your
for
Honor,
Nevada Beverage?
Yeah. Our preference would be the 9th, Your Honor. There are pretrial motions that are due prior to the 16th, and we'd just like to have this buttoned up to make sure we don't miss any deadlines.
Okay. Remember, I need people saying their names when they're speaking, please. Otherwise, my court recorder is going to continue to give me looks, please.
Your Honor,
My
David,
apologies, Your Honor. Colt Dodrill, Bar 9000, Counsel for Nevada Beverage. Our preference would be to have it heard on the 9th prior to the deadlines for pretrial motions.
Your Honor, David Spurlock, we would agree with that.
Okay, well, right now, the only one I'm setting is Nevada Beverage because that's the only one I have. I will set that on the 9th, get that taken care of. If Whole Foods chooses to get something quickly to the court and request that same date, I'll evaluate it when I get it because I can't make advisory opinions. Does that work for you, Counsel for Whole Foods?
It does, Your Honor. Thank you.
Does that work for you? That was Mr. Spurlock on behalf of Whole Foods. Mr. Dodrill on behalf of Nevada Beverage. Does that work for you?
That works for me. Thank you, Your Honor.
Mr. Parker, you were standing up on behalf of plaintiffs. Did you have something you'd like to put into this?
You've done exactly what I wanted to do. Again, Teddy Parker on behalf of the plaintiffs. We thought the sooner the better because of the pretrial motion deadline.
Okay, can I quote that caption for future cases, what you just said? Okay, so since it's moot, is the motion, are we just treating it as moot, is how you want the record to reflect versus withdrawn?
David Spurlock, yes, Your Honor.
Okay, so then motion's moot, joinder's moot. Since I have you all here, you probably, and I said this what I was going to do today anyway, on your jury questionnaires. Friendly reminder, order inbox is order inbox is order inbox. Please do not submit anything else to order inbox. Not saying who did on the proposed jury questionnaire, but remember only proposed orders to the order inbox. That being said, here's what, taking into consideration everyone's position from last time, including Mr. Kemp's position on behalf of plaintiffs, where he's talked about it, also speaking with the jury commissioner, given the time frame and given the fact that we may or may not have a new system in the intervening time, in order to minimize any impact on your case, we're going to do one written questionnaire similar to which whoever's typing, please put yourself on mute. Thank you so very much. We're going to do one questionnaire because realistically, when you look at these timings, if we do it the other way, you're going to have people way too close. We're close already with the holidays, whatever you're celebrating in December, right? Mid to late December, whatever people are celebrating. So to minimize that issue, I'm inclined to do, this is the last chance for someone to vociferously say if they object. Everybody told me the opposite last time, but just do, here's what the court's inclined to do. We will walk through it. Yes, we will send you an email, but you might want to take notes on what we're inclined to do. So if anyone's not here, then you'll still get an email with these. Okay, what we're inclined to do is 11/1/2023, i.e. tomorrow, Jury Services sends out approximately 3,500 juror summonses to report for various dates between 12/1 and 12/15 to complete a written questionnaire. There would not be an ability to serve questionnaire for all the reasons the court just said, taking fully into account everything everybody said last time, because this seems to be what you want anyway. I am going to say the Tuesday before Thanksgiving, so that is 21st, November 21st. Counsel would need to provide 1,200 court approved. So this is for jury services. I'm going to give you a different date to provide to the court, and I'm given something just came in late last night, this morning. I'm going to have to revisit something versus already what I have here. So this is to go to jury services. These are the copies. This isn't to get it to the court on the fully approved if I have any questions on a proposed jury questionnaire. But for jury services, they're going to need 11/21, 1,200 court-approved, agreed-upon pretrial questionnaires, blank copies with the judge's signature and admonition. Remember, it's only going to have the juror badge number. It's not going to have their names anywhere on that. And we're going to have me do my admonition, okay? We're going to have to do a date before that when I need the admonition, when I need all these things taken care of, and I'll deal with that in a second. But let me get through these dates, and then I'll circle back to the other ones. 12/1 to 12/15, the jurors are going to report to complete the pretrial questionnaire, and that's going to be based on jury services determination, right, of A, how many people have responded, B, what needs, the needs to get people in, okay? So 12/18, copy service would need to, whoever's arranging for the copy service would need to pick up the questionnaires for copying and delivery to counsel, whether you're doing electronically, etc. Remember, we're going to have to add something to, like your CMO or whatever, that makes sure these all are consistent with Stevens Media, right? So that they're not okay with certain information. We need to, we're then going to do, preference on this court is to do a staggered approach for excusals, meaning as we get people like for the first week that we batch it to you, right? First week to 2 week, So what I just said about the picking up the copying and delivery to council on 12/18, there's a potential modification there because I'll tell you, people found it more effective. The last case is like, since they're coming in between 12/1 and 12/15, some people like a staggered approach getting. Okay, somebody needs to mute themselves. That's the reason why I'm coming across as an echo. Thank you so very much. So two options there. One, you pick up the bundle, right, of whoever has filled out the questionnaires on 12/18. Other option is we break this down to two groups and you pick up the first bundle, you know what I mean? The first ones have been like for the first week and a half and then the second week and a half. Jury services, it's easier for them in one bundle. If you all are going to push for the two bundles, I just need to know, okay? Sometimes people push for that. And everyone understands what I mean, one bundle versus two bundles?
Yes, Your Honor.
Okay. I'm using some of the phrasing that I've used in other cases, so if you're not familiar with what I'm saying, just please let me know and I'll be glad to clarify. Okay, so 12/20, well, once you pick them up and you get the jury services right, I mean, you get the jury questionnaires, you review them. They're all going to need to come back to the court by, when I say the court, I really mean jury services, right? Once again, that's got two ways of doing it. Usually it's preferable to do staggered, right, so that jury services can start working on excusals in two batches versus one batch. But I'm also appreciative you all, this has an interesting concept with the holidays, right? So no matter what, it all has to be done by January 3rd, okay? The court's preference, because I have seen it work better, is that we do that in two batches of your responses, right? That I give you two dates, like a few days apart or a week apart, because then jury services can start dealing with the first group before they have the whole group versus getting it all together. But once again, I'm also trying to meet your expectations similar to what you may have had in another trial, but I also have, this is not my first, second, or third time doing these, so I've done this a decent number of times. And so this is 1/3, and then trial starts 1/16. Right, Mr. Cavanaugh? I said the right date this time, right? I'm good?
Yes, Your Honor, you're good.
Okay, no worries. I felt bad when I said the wrong date the other day. So, okay. Okay, so 1/16, the trial starts. So this trying to balance when your trial starts, when you have a finalization for your jurors, etc. Remember, of course, your similar concepts. I gave you some stats last time about how many people, actually failure to appear, actually show up, fill out questionnaires. That's the reason why we went up to the 3,500, because taking into account holidays, etc., realizing that you might have about a 1/3, okay? I will tell you before I continue on, Whole Foods and Nevada Beverage is more than welcome to stay here. You're still technically in the case. There is no orders out there. But this court's not requiring you to stay, so it's really up to you. So you need to evaluate what you think is in the best interest of your clients. And I'm going to continue with all my informational aspects. Okay, so, and the voir dire, we're not going to work today because A, I'm in the middle of trial, B, I've got other things that I've got right on my morning calendar in fairness to their trial and everything else. We're not going to work through how we're going to bring the jurors in for time of voir dire in January. We'll get there next. But let's just walk through, first off, other than I have not yet said when you all need to get to the court to finalize ones, but you can appreciate, given the timing, this proposed questionnaire of 30 some odd pages with the multiple questions, you can appreciate the court hasn't. So first question I have before I go to all these dates is the proposed questionnaire that was sent yesterday at 5:05 p.m. a joint agreed upon questionnaire, or is there, I don't need to know what everyone's argument is. If there's a disagreement, I just need to know, is it the one that the court should be reviewing as final, and the court just reviews it to evaluate as it needs to, or is there some disagreements that the court's going to need to address? Counsel for plaintiffs, what's your perception?
Your Honor, after our last status check on this issue, I sent around a copy of plaintiff's proposed questionnaire. I did make some changes to reflect some of the proposals in the opposition to the motion for a questionnaire. I asked for any additional changes in red line. I never heard anything back. I had my office submit that proposed questionnaire last night because it was my understanding the court wanted a copy of it by the 30th. So that's our proposed questionnaire. the proposals that I was aware of from the opposition that was filed to our motion for questionnaire. But if there are any other changes, I'm not aware of those. It's up to the defendants.
Okay, I appreciate it. Thanks. Real Water.
Good morning, Your Honor. Joel Odou on behalf of the real water entities. I have not had an opportunity to check the recently filed questionnaire, but I'm sure it's pretty close. I think that there may be one or two changes, if at most, but I think we're very close.
Your Honor, I should add to make things easier. I'm happy to send that draft around to everyone and give them an opportunity to review it and weigh in and get back to you tomorrow with either a final agreed upon version or any red lines to that's proposed that we don't agree to.
Okay. If I say Friday, I need final, joint, fully agreed upon, yes, and giving you a couple extra days because people might not have realized, over the longer weekend, things might have been doing other things, but okay. And if there is any alternative proposals, I need a red line version, right? So if it's a delete question, I'm randomly going to pick 62, right? Then I need it in red line that's got dashes, right? So it's deleted, and who's requesting it, and if it's more than one party, so I can take a look at it, right? And if it's adding one, same thing, adding it in which parties, okay? Does that meet everybody's needs? Counsels for plaintiff, does that meet your needs?
Yes, Your Honor, that's fine with plaintiffs.
So you don't feel left out. Whole food entities, does that meet your needs?
Meet our needs, Your Honor. And if I may, Your Honor, David Spurlock, I have a 10 o'clock deposition, so I'm going to.
Nice to see you. Have a great rest of your Nevada Day and happy Halloween. Thank you so much.
Thank you.
Nevada Beverage, does that meet your needs? Just in case you're leaving as well.
Haven't left yet, Your Honor. I have no objection.
Okay. And that was Mr. Dodrill on behalf of
That's
Nevada
Mr.
Beverage.
Dodrill,
Thanks.
bar 9000. I apologize.
Thanks. Okay. Hanna Instruments SID entities. Does that meet your needs?
Yes, Your Honor, this is Ryan Flanagan. It meets our needs. Thank you.
Okay. NSF, does that meet your needs?
This is Jonathan Fountain for NSF. Yes, Your Honor.
Milwaukee Instruments, do I now have anyone from Milwaukee Instruments? This is your final?
Yes, Your Honor. Sorry, the mix-up this morning. Rob Robbins, 6109. No objection, Your Honor.
Okay, any objection to anything I've said previously? If so, let
No,
me know
Your
now.
Honor.
Okay.
No.
Costco.
Noushan Noureddini on behalf of Costco. No objection.
Okay, ETT1, please.
Jan Tomasik, bar number 151's are in agreement as well. Thank you, Judge.
Thank you. Real Water, Tennessee.
No objection, Your Honor.
And that's Mr. Cavanaugh. Okay. Have I missed anyone? Any of the ProHawks need to weigh in? I'm hearing silence. Okay. So that's that. So now I need to know when. So I've given you that date. And then what the court's going to do is the court's going to review it as quickly as it can and get it back to you all. And I've already given, so obviously I'm going to have to do it before the 21st so that whoever's going to be taking responsibility to get those copies made. Okay? And get those taken care of. So a couple real quick things I just need to follow up on, and then we're going to take the other cases, is with regards to providing the information back to the court to send to jury services with excusals. What we have found helpful in the past is somebody volunteers to make a nice big Excel sheet, right? And that Excel sheet has the column, right, of who the parties are jointly excusing, all right? Who maybe one party wants excused, but there's objections. I'm going to tell you right now, if one party wants it and there's objections from others, that person is going to stay on the list because that's the fair thing to do, right? Because the only reason why excusals prior to jury questionnaires, in the case law, is if it's a stipulation, because then the court doesn't have to make a ruling. I will say if somebody provides some unique issue, that the court needs to have a hearing, you're going to have to do that by motion, right? In a written motion. I've never had somebody have to do that, but if that's really comes up, then I give you that option too. So everyone has an opportunity to be heard if they really need to, if they wish to be heard. Because the easiest way is going to be to send back, that group XL of who you've excused, and then we can utilize it, to add in. And I let jury services, under the statute, as you know, there's certain exemptions and mandatory excusals. Is there any reason not to have jury services do their job and they take care of that? Meaning somebody who is police officer, somebody's over 70, etc. Legislature is not in session, so that one doesn't count. But is anyone going to object to letting jury services do their job and do the mandatory excusals and exemptions? If somebody does not think jury services should do that, now is your time, please, to speak. I'm not going to go around to everyone. I'm just really going to say first here in court, and then I'm going to say remotely, so that everyone has an opportunity. In court?
Nothing on behalf of the plaintiffs, Your Honor.
Pardon?
Nothing on behalf of the plaintiffs. We don't disagree with that.
Okay. Anyone remotely want to be heard? I'm giving an extra second in case people couldn't turn on their mics. No one's turned on their mics. No one's put anything in the chat. I'm not seeing anyone giving me any kind of indication they want to be heard. Okay. So, obviously, statute provides they can do what they need to do. The 2 rounds of providing the excusals versus the 1 round. I am cognizant it is the holidays. You all want to go to trial on January 16th. These are the dates you need versus, in order to meet your deadlines, which the court's fine with. But do you want it in 1 batch or 2 batch as far as providing the information? I'll tell you the court's preference, like I said, is 2 batches because particularly you're asking jury services during the holidays to jump through a lot of information. If you anticipate that we get a return rate, which is typical somewhere between 27 and like 40%, right? Usually it's in the 30s, but that's a lot of questionnaires for them to be going through, right? On short staffs during that time period. So why 2 batches makes more sense, but let me hear what you all want to do. Counsels for plaintiff, do you have a position?
Yes, Your Honor. Plaintiff's preference would be in at least 2 batches, and even if it's possible to do more, to pick them up as they're
No, they have, jury services has a job, right? 51 other departments. You know what I mean? They can't do it. I can ask for 2 batches, but you have to return them in 2 batches, meaning you're going to have a shorter deadline for the first grouping to get back your answers, right?
Your Honor, plaintiff's preference would be 2 batches.
Okay. Counsel for defense, who wishes to be heard?
Your Honor, Joe Ladue on behalf of Real Water, if I may, please.
Of course. Go ahead, please.
Your Honor, in the Gallagher trial, we did them in batches, and certainly we would ask for 2 batches. The way we did it, and this may or may not meet the court's needs, was we received the batch from the court in a Word document that was given to the plaintiffs. The plaintiffs then worked with our office. We coordinated with the defense and returned a list of excusals back to the court with just the list of the agreed upon excusals. It was in a Word document, not even in Excel, but it was agreed upon by all parties, and it was fairly easy to do considering the number of jurors that we went through. And so we would request to do it that way in 2 batches, get the list from the court so it's in the court's order, badge order, or whatever order they're going to be called, and they can be excused that way. That would be our suggestion.
Which you can appreciate who created that Word document, right? It wasn't you all. You probably don't know how much time was taken to try and create said document. You can appreciate that we have effectively utilized Excels created by counsel because that way it's manageable. You can redo the cells, right? You can group it from if you have big gaps, etc. It's a lot easier to work with. And we ask counsel to do it because you all requested the jury questionnaire, right? You have hundreds of people, resources. I have 1. Any reason why you all can't create it? If you want it in Word versus Excel, I'd be okay with that, but you all have to create it. Excel is just so much easier to work with, folks.
Your Honor, if I can, I completely agree. That's not a problem, us making it in Excel. What Mr. Odou is referring to is it was the court's preference in Gallagher that the parties not create it. We actually wanted to create an Excel spreadsheet and did for our own purposes, but the court was insistent on using the list they created. So that's not an issue. I think it's better for both the court and the parties that we create the Excel spreadsheet.
So, is there a reason? I mean, are you... And remember, folks, this is Hunwardsen. It's not Gallagher. Trying to help you all with expectations, right? But at the same time, 2 different cases, different grouping of plaintiffs, different grouping of defendants.
I think Mr. Odou is correct on... I don't think we're talking about anything different. It's just form rather than substance. We'll meet, confer, agree on the excusals, submit that to the court. It's just a matter of if the list is created by us or the court, and it's
going to be created by you all. I mean, realistically, folks, it's
We're happy to do that, Your Honor.
3,500 names by one of your firms to be doing it is going to be, and remember, it's not even going to be names, it's just going to be badge numbers. You're going to have a badge number, you'll be told the badge number ranges from X to Y. Realistically, you're just popping those in to cells, right? And then you're having, now if you want a different Excel for your own purposes, fine, but it's an easier way to do it because we can sort. Look, the failure to appears can all be sorted in one thing, so you know why your range gap is missing, right? And it can just, it can be done more efficiently and quickly. If I'm missing something, let me know, because I'm not wedded to Word versus Excel. I'm just wedded to an efficient means that doesn't have people recreate the wheel and allows everyone having full due process ability to have their case heard, their case defended, but we're not spending unnecessary time trying to do PDFs, turn them into edibles and have, edible PDFs, and then trying to recreate those with having to basically retype everything. And please don't give me anything in TIFF. But like I said, what's efficient, folks?
You're exactly right. There's no dispute on this.
Okay.
We'll handle it that way. That's not a problem at all.
Mr. Odou, am I missing something? I mean, are you wedded to Word versus Excel? I don't, like I said,
No.
I just want it efficient.
Joel Odou on behalf of Real Water. No, Your Honor, it was efficient to do it that way. It's efficient to do it this way. We just want to make it as easy as possible on the court. And Mr. Pepperman will take the lead on that. That's fine.
Yeah, I mean, am I missing something on a Word document created by the court that's just going to have a listing of numbers? I mean, it's not going to, like 1 to 3,500 or whatever it is.
It had names as well.
Pardon?
It did have names, Your Honor. It had names and numbers, and it was fairly efficient to go through that way, but whatever we need to do.
Well, there's a difference of viewpoint about whether or not, right, the names issues getting it way up front versus right close to the time of trial, because I have to balance the privacy needs, right? Stevens Media, all that information is out there. I have to balance the fact that there are certain ethical rules that do allow certain investigations, but not other types of investigations. Also try and minimize people raising any issues about the extent of said investigations, since you're only supposed to utilize the answers to the questions for evaluating whether or not you wish to stipulate or evaluating for purposes of bias. It doesn't matter what a person's name is. And sometimes people have raised the issue when you have the names too early that people might be trying to exclude people based on who they think their names are and if it goes to potential demographic groups. So we eliminate all of that by just utilizing badge numbers. Then we give you the names closer to.
Yes, Your Honor. So as I understand it, in 2 batches, after half of them fill out the questionnaires, we'll be contacted by jury services to pick up the filled out questionnaires. We'll be given a list of all the names and badge numbers of the people who filled out those
names.
questionnaires.
Don't say names, because I keep on telling you I'm not listening to badge numbers only. Not going to be names.
But we'll receive the list of names from jury services of the people who filled out the questionnaires separate. Correct.
Not at the time you're getting the questionnaires. That will be closer to the time of trial after you all have done all your stipulated excusals, because the point is you're not supposed to be doing you're supposed to be doing stipulated excusals based on the answers of whoever the person is, regardless of what their name is, right? Based on their answers to those questionnaires.
Okay,
Not because they have a name, John Doe, Jane Smith, etc., right? And you're not supposed to be doing outside investigation for purposes of juror questionnaires, right? Because if you're doing stipulations, those stipulations are supposed to be either is based on their answers you think that they should be stipulated out. That doesn't take into account your rights during the actual voir dire process, right?
Okay, I understood. So we'll be provided just a list of the badge numbers who filled out the questionnaires. We'll put those badge numbers in an Excel spreadsheet and confer on whether we agree to excuse any of those particular badge numbers. We'll submit our list of agreed upon excusals in 2 separate batches.
And I'm going to confirm with jury services because of the timing. I wanted to see what you all wanted, right? Okay, so
Yes,
like
that would be our
I'm
preference, Your Honor.
okay.
To split it up.
Yeah. And we'll be sending you an email with like what some of the cell type things need. And if you want it in Word, just give a reason why you want it in Word, okay? Just something that we can utilize in an easy form to get you taken care of. Does anybody else have does anyone have an objection to that or some better suggestion that they want to be heard? Now's the time, please, folks. Okay. So I'm going to
Joel Odou for Real Water, just a clarification. So the order that they're going to appear on this list as the order that we're going to be calling them to sit in the box?
That is a yes and no question, because as you know, you might have the following. You might have badge number 1 has filled out the questionnaire, right? And then you step to excuse. So maybe your first person actually showing up to court might be badge 56, right? Then you might have a gap all the way to badge 72 because of either excusals, failure to appear, all sorts of things. If you're asking in that numeric order in a general sense, lowest number to highest number, that generally is the way it is done. Is there a reason that somebody's requesting something different? Today's not the day because I've got just too many other people, right? Looks like I'm seeing you on the 9th anyway, so shall I add to the 9th a status check in addition to those 2 motions on OST, the 1 motion that I currently have, and a potentiality that I might be doing a second motion? Do you want me to add a status check to that so you all can think this through for the next week, and then we can walk through if there's outstanding questions? Would that meet your needs better than trying to do it top of the head today? Mr. Odou, does that meet your needs?
Your Honor, the court's answered my question. I don't need a status check. Thank you.
Thank you. Anybody think they want me to add a status check to that? I'm just trying to make sure everyone gets taken care of. Yes, no, maybe so? No.
On behalf of plaintiff, Sean.
Okay, any other questions? Any other thoughts? Okay, since I'm in trial, probably might not get this email till tomorrow. I'll try today, but it's a matter of balancing trial and everything else. Okay, so I gave you the proposed dates. As I've told you, I need to double check with jury services, given that this is right around the holidays. If the 2-batch aspect is going to work, I understand that's the preference of counsel. We'll try and get that done. And I'm going to then, when we send you the email, the dates by which counsel need to respond with each batch is said we could do 2 batches. If it's 1 batch, then the 1 batch date. Anything else on behalf of plaintiffs?
Nothing else, Your Honor. Thank you so much.
Anything else on behalf of Real Water?
No, Your Honor. Thank you.
Do all the other parties wish me to go around one by one, or can I just do a global anything else and let you have an opportunity to speak? Anything?
Sorry, Honor, I do have one thing.
Wait, hold on a second. Let me finish with anything else on anyone remotely.
Global fine, Your Honor.
Okay, so I'm hearing the fines and I'm seeing some negatory nods, so I'm taking that as taken care of. Okay, counsel, go ahead on behalf of plaintiff.
Just in the sense of when you speak to jury services about the process, 2 batches, 1 batches, we're flexible. Whatever's easier for jury services, we'll be able to accommodate. So if they come back and say it's easier for us to pick up the questionnaires every day they're completed, we'll do that. So if they come back and propose something different, the parties are flexible and we'll make it work.
Is plaintiff taking the point and plaintiff's getting the copying services?
Yes, we took the lead in doing that, and we shared the cost last time, so I anticipate the same thing this time.
Okay. If anyone has an objection to sharing costs or something like that you need addressed, please send the court. Just do a request for a status check, and we'll get you taken care of. Okay? I think we've taken care of anything else. If not, wish everyone a great rest of your day. Happy Halloween. Happy Nevada Day. And we'll see any people on the 9th, and I'll be seeing some things on the jury questionnaire by the end of this week with Redline. Thank you so much.
Thank you.
Take care.
Thank you,
Page 30. Thank you.